believe this is Mr. Reed's motion to compel discovery related to some ongoing efforts. We were last here, let's see, I'm going to pull my Odyssey, it's going a little slow. We weren't too long ago talking about presentation of an order related to service and the like. And I believe this issue was raised, but was not fully addressed, and we set it over to address today. Is that your recollection, Ms. Cotto?
That's from my notes from Mr. Ammons, because I was in another hearing, and that's correct. Was that the court entered the order on from I guess a hearing a couple of weeks ago, but did not address anything regards to the motion to compel. I have not submitted a proposed order because one doesn't always know what the court's going to order on these matters.
Right. So looking back at the minutes from May 9th, when our last hearing we had, Mr. Ammons was present in place of Ms. Cotto, and Ms. Fowler was present. And we talked about signing off on the order, and that I did. And then we also set the matter over to today at 9 o'clock in the morning. She was present. And I'm not sure why she's not here today. I was going to ask Ms. Cotto if you had any contact from Ms. Fowler, but I understand there's probably not going to be much direct contact via phone.
There is no contact between myself and Ms. Fowler. She used to contact me only through USPS and private process server.
Right. So you filed a motion to compel back on April 10th, laying out the specific bases or different foundations for that. And I'm just looking to see if there was a responsive pleading filed by Ms. Fowler. I don't recall seeing one. Did you receive any response to your motion?
No, and one of the things that's happened in this particular case is I received a number of documents that are not in Odyssey, and I never received anything that was in Odyssey. The documents I have received are not under the penalty of perjury, not, their data, but there's no place of signature. I don't think that in itself is a problem. The latest one, I did get something that says under penalty of perjury, but I don't believe that's properly before the court. So I haven't gotten a response that's filed with the court, is I think where I'm at. This has been kind of an ongoing issue.
Okay. So in response to the motion to compel, I see on April 28th, Ms. Fowler filed a response to defendant's motions, and she says that she denies defendant's motion to compel and asked for an award of attorney fees for filing bar complaints, an order limiting abuse of litigation, a CR 11 sanction, and other relief that might be imposed. On that same date, she filed the 25-page declaration. Well, there's attachments, basically 2 to 3 pages. She indicates that she has some concerns about providing documentation related to her Social Security number. She said that interrogatories have been filed with the court. She said that she's provided everything. And she said that they've had a 26I conference, and then she's filing them again, the interrogatory answers. So she goes on to talk about that and talks about other information. Then, and that's not under the penalty of perjury. There's one document that is under the penalty of perjury. It said it's about ex parte communications that she has some concerns about. And then she talks about the FBI and the DOJ and other things, and concerned about her information. And then she talks a little bit about some 26I conferences on page 3. She said, again, just basically reiterated what she said before in her earlier declaration, that she's provided everything. And then I just want to make sure I'm just covering everything that she submitted.
I don't think that's under the penalty of perjury, Your Honor.
I agree. All right. And so those documents have been filed. And then I just want to check with Ms. Cotto with the April 28th declaration that was submitted that had has some exhibits associated with it. It's a criminal history of Ms. Fowler. There's a bar complaint. There's a declaration of Mr. Ammons' assistant. Then there's respondent's first request for discovery information from the petitioner. So there are some answers provided there on those. But your position is that she submitted those, but those are incomplete.
Well, Your Honor, I haven't seen those. They have never been served on me. And they are not, I don't know if they're complete because those particular documents have not been submitted. And there's nothing signed under the penalty of perjury. There's significant concerns I have in regards to getting information. I'm not going to go through and answer every single allegation Ms. Fowler makes, but I can tell the court I have not had any ex parte communication with any judicial officer, especially in this case, given the 22 bar complaints that have been made, all of them being unfounded.
Yeah, I'm not so concerned
Okay.
about that. I'm more concerned just about the discovery issues, since we're here for a motion to compel.
Never seen anything and never received anything. Haven't received. We've done the CR26I as required. I've done it several times with all the different attorneys.
Mhm.
We did the last one with Mr. Anagnostou, who was her last attorney. The previous CR26I was in regards to Ms. Winkles asking for information from me. We didn't get a chance to discuss the information coming from Ms. Winkles. So that's why in my responsive declaration, usually they're much shorter in motion to compels, kind of explaining what had happened. I'm still not received anything. Nothing's been signed. Nothing's been given to my office. No documents. I can tell the court that any of that information doesn't leave my office. It's protected, and given allegations, my client won't even get a copy. I will go over some of the information pertinent to the case, but we can't proceed without it. And everything I'm asking for is relevant to completing this particular case. It is a child support modification. I'm asking for bank records. Those won't leave my office. If the court orders me to not show my client her social security number, I don't have a problem doing that. She actually filed her social security number in another document previous in that, and I have not shared that with my client. I'm just asking the court for an order compelling her to provide my office with not only the discovery but the attachments, that I should have fees. I'm not asking for fees because of bar complaints. I'm asking for fees because I've had to come back repeatedly. I've repeatedly given her a lot of latitude because she's represented herself to give me the information. She's not providing it.
All right, thank you. I did review. It looks like the discovery request was initially made in October of 2019. That was served upon Ms. Fowler. In 2021, there were at least 4 attempts to set a 26-hour I with Ms. Fowler's then attorney, Ms. Lynn. Ms. Cotto documents or indicates that there was another attorney, that there were efforts to get the discovery, but they were unsuccessful. And then the most recent one, 26I with Mr. Anagnostou, there was a 26I that occurred on February 23rd, and there was an agreed date on which those responses would be filed by March 23rd. As of April 8th, nothing had been submitted. April 10th, the motion to compel was filed. There is a declaration submitted by Ms. Fowler on the 28th. It's not under the penalty of perjury. It purports to provide some emails. It has looks like a billing system from an attorney. There's an affirmation of Ms. Cotto that's submitted. Then there's a criminal history check of Ms. Fowler. And then there are also, there's a response from Ms. Foster related to sent to the Bar Association on behalf of Ms. Cotto. There's a declaration from Ms. Specht, who's a legal assistant to Mr. Ammons. And then there's pages 18 through 25 are responses to the interrogatories. And that's where Ms. Cotto indicated that she has not received those. And they seem, for example, under interrogatory 1.3, basically where she's lived in the past, and also the monthly rent, address, phone number, landlord, addresses of other residences, whether there's a rental or lease agreement and the like. And she says, in response to those, she says, all filed in court and attached. So that seems to be incomplete because there's no attachments that relate to that. And there's also, there's incomplete answers related to employment periods. So there's some incomplete, notwithstanding that there's a submission, but it's incomplete, and it's not dated as to when she signed the responses to that. Ms. Fowler was here at the last hearing on May 9th. I'm not sure why she's not here today. This has been dragging on a very long time, since October of 2019, as far as discovery. So I'm going to grant the motion to compel in order that all answers be submitted and completed fully and appropriately, no later than June 13th at 9 a.m., where they need to be submitted at that time. I am ordering attorney fees of $500. This case has gone on for a very long time. I'm not sure if Ms. Fowler was possibly injured or is unable to make it here today or what have you. We can address that if she comes forward with concerns about today's hearing. So with that, then Ms. Cotto, I'd anticipate you'd be submitting an order compelling and granting the relief that was requested in your motion, along with the $500 of attorney fees, and to provide complete answers and provide documents as requested. And with the language that if there's a failure to do so, there's a distinct possibility of striking of pleadings.
Okay. So is the court saying, as far as failure to comply with the dates, that further sanctions may be considered, or?
Yes.
Okay.
Yeah.
I'd like to put this on for presentation. I can also tell the court, as an officer of the court, I did not receive any messages, even through the process server who showed up yesterday, that she was not going to be here. So, okay. So can we put this on for a presentation in front of Your Honor?
We can set it to, I mean, we could set it for 2 dates proposed. One would be May 30th, or the other would be, we could just set it on the 13th of June.
I'd like to get the order done before the 13th. So I'd like to do the 30th for the presentation of the order, and then
compliance review on the 16th.
Right.
Or 13th, pardon me. Let's do that.
Yeah. So,
all right.
So my dates are May 30th and June the 13th.
Yeah. So,
correct? Okay.
Yes, May 30th at 9 a.m. for presentation of today's order compelling discovery. Yeah, June 13th, Tuesday, will be a review to see if she's complied with the court's order.
Okay. All right. Those were the only issues then before the court. Thank you.
All right. Thank you. All right. We don't have a docket next week. The 30th, I won't be here. And so the next available date would be on June 6th. So we could look at setting the review of the budget, so we can assess his plan to comply with the spousal maintenance award. How does that date look for the parties?
That's fine.
That's
That works for me.
Okay. All right. So Mr. Morrison, if you'll quickly get your budget sent out to the parties, including myself and Ms. Bliss, and do that hard copy, and also email that would facilitate us having that review.
Okay.
And then let me just ask a follow-up question. There was from our last hearing, there's an indication that, the court ordered that Ms. Mortensen be removed from the credit card. Has that taken place?
I'm getting on that today. I've tried to get a hold of the person at the bank that I have been directed to, and she has been unavailable for the last week or so. And so I'm going to try to get on that today and get that taken care of.
So, Mr. Morrison, I'm concerned about that statement. We were here on April 18th, and the court ordered you to take action, and you took action last week on basically 3 weeks after the fact. I'm concerned about that. Why didn't you do it earlier?
Just busy. I don't have an answer for you, sir. But I'm going to take care of it, and it will be in my name only. And I'm going to try to do it today and get it all taken care of and done, and get them paid on that.
I would strongly encourage you to remove the word try and be successful and complete that today.
Yes, sir.
I'll be looking very carefully to see when that she was removed from the card. If it's not today, it better be the next day. Take action and take it quickly. We're not messing around here. When I make an order, I expect you to comply with the order. And I'm concerned that you didn't submit the monthly budget. I understand the mail may be an issue, but the U.S. mail is pretty darn reliable. Things do happen, but in my experience, sometimes people don't submit it. And so I'm not saying that didn't happen with you or did happen with you. I'm a bit skeptical just because of your lackadaisical approach to the credit card and the order that I imposed. So that's enough for today. And we will see you and all of the proof that you've removed her from the credit card, and proof that you've submitted the proposed budget to both my assistant and to Ms. Bliss and to the court clerk. We will see you on June 6th at 9 a.m.
Okay. Thank you, Your Honor.
Ms. Bliss, any final items?
Were you going to enter my order as it was presented, maybe changing the due? I don't know if Your Honor wants to change the due dates for removing her from the card and preparing his budget, since it wasn't by today. That was the initial order of the card, but I don't know if you want to change that or leave it as is, and then we'll just come back on June 6th. I'm
going to leave it as is.
Okay.
And sign off on that. Mr. Morrison, did you receive that proposed order that Ms. Bliss prepared? The title is Order on April 18th, 2023 hearing.
I believe so. I know I got the $350 attorney fees.
Yeah, that's the one.
Yeah, I did.
Okay. And do you have any objection to that order as being an accurate representation of what happened on April 18th?
No, that's what happened.
Okay. I've signed off on that proposed order, and I'm handing that to the clerk for filing.
Thank you, Judge.
All right, we'll see everybody on Mr. Reed is present and Ms. Green is present, and I'll just double check. Andrew Giske, are you on the line today? Okay, and then Cami Jo Giske, are you on the line today? I do see. Okay, looks like both Ms. Giske and Mr. Giske are present, so welcome to everyone.
Sorry about that. Yes, I'm here.
Okay, great, thanks. All right, so we're here today for a presentation from our prior order, and there was one concerns one concern related to ensuring cleanliness of the home. So that's kind of where I'm at in looking at things.
I believe the issue was decision-making.
Yes, Your Honor, there's two issues. We had asked about confirmation that the home was clean before visits.
Mhm.
And Mr. Reed had asked that joint decision-making be ordered, not sole decision-making, which is what is in the orders. And I do want to bring to the court's attention, it does look like all the orders were entered on May 9th after our previous hearing without any changes. Since we had some time this morning, I did look on the docket. So I do want to bring that to your attention that I'm not sure if you've already reviewed these issues and made decisions or not.
Yeah, I noticed that also, the child support order, the child support worksheets and the parenting plan and the family law, temporary family law order were entered. So let's just take a look at that. There was the issue about the decision-making. And I apologize, I don't have that at the forefront of my mind, so I'm just going to turn to both parties for just a quick refresher to have that brought to the forefront. So maybe I could hear from Mr. Reed and then Ms. Green.
Sure, yeah, and as to decision making, our issue was that the concern was the cleanliness of the house, and we felt that didn't really have any bearing on whether there should be Mr. Kiskik should be involved in decision making regarding the school and major health issues. So our feeling was that there really was no basis for a sole decision making on mother's part. As to the other issue that Ms. Green has brought up, which is evidence of a clean house, we don't really have an issue with that. We've offered photographs and we'll continue to do so.
Thank you. Ms. Green.
Yes, Your Honor. So I entered the decision-making as sole decision-making because you adopted the guardian ad litem's report for the majority of her recommendations. And basically all of those are in there. And this was Ms. Fellow's recommendation. There'd be sole decision-making on the basis of 3B above, which is the neglect found from the unclean home, the parent's ability and desire to cooperate with each other in decision-making. Basically throughout this process, there's been repeated filings of allegations that the child had been abused and father had taken the child multiple times to medical providers without notice to my client, which has been resolved now. But, you know, ended in a protection order that was issued until the guardian ad litem report came out. And then the distance between the parents' home, my client is in Oregon and Beaverton, Mr. is in Woodland, Washington. They're already meeting at a halfway point between in Vancouver. So really, because of the amount of conflict and the issues that have come to light, and you have changed custody to mother, we're asking that she be able to make those decisions without interference and substantial involvement with father, given the history in this case.
Ms. Fellows. Thank you, Ms. Green.
Yes, Your Honor. You did take issue at the hearing that we were at on April 18th, it looks like, that the father was to make significant efforts to make sure that his home is sufficiently clean. And if the court gets wind that it's not, you would be willing to look at restricting his time. So the court really did, you know, take a strong stand on that. So the parties did come up with the father providing mom some pictures just prior to the visitation. They did that, I believe, was on Our Family Wizard, which I have access to and can review. So that was appropriate. And I think that is a good way to do that, as long as the pictures are current pictures just prior to the visitation. And I think, and I hope that the father will honor that. As to decision-making, I did recommend that it be limited to the mother, that there, because of the findings of 3B, but more importantly, because of the distance. Dad does live in Woodland, mom lives in Beaverton, so there is that distance, as well as the lack of cooperation between the parents. So there has been a lot of conflict throughout the time that I've been on the case. Since the parenting time has been changed and mom is the primary, I have noticed on Our Family Wizard that they are trying to communicate better, but I just really stand by my recommendation that it should be sole to the mother, sole decision-making to the mother at this point in time.
Thanks, everybody. I appreciate that. I also took an opportunity while listening to each of you to review my notes from the April 18th hearing. And kind of the way I do my notes, I put a little orange star next to decisions that I'm going to make related to certain things. And I did indicate that there would be limited decision-making to the mother, principally because of the neglect finding, concerns for the absences at school. I think there was 44 or what have you. And then the cooperation is an issue. The distance to me is not as big a concern. It sounds like it is to others, but to me, it wasn't as pressing. So the May 9th parenting plan that I signed off on does have the limited decision-making to Ms. Cami Jo Giske. So I'm going to leave that in place. And it sounds like the parties have addressed the cleanliness issue with photos. So
Your Honor, as to the photos, I wonder if we can maybe have a time limitation on that. I'd hate to think that when the child is 17 that they're still taking photos. It seems to me maybe 6 or 9 months would be more appropriate.
Thank you, Ms. Green.
So, Your Honor, I'm expecting from what you've just stated that you're just leaving the current order in place and not making any changes.
Yes.
So it sounds like this will be basically an unenforceable agreement anyways. I would just ask that it be in place, at least for the time frame that the temporary orders would be in place. Usually we hope that won't last more than a year, but it depends on how the parties proceed. So this is basically just a dicta, I guess, at this point, and something that the parties are agreeing to on the record.
Thank you, Ms. Green.
And Ms. Fellows, any comment on that?
No comment, Your Honor.
Okay. Yeah, I think that's fine. As far as it's included, it's kind of an informal agreement, and until it could be raised at the final in the final parenting plan, and we can address it if it needs to be memorialized at that time. Then it can. If things have been going well and much improved, then it may stay off. So we'll just consider that formal agreement on the record as far as the photos extending until at least the final parenting plan is entered.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Great. Thanks everybody for your input. Any final issues on the case today? We're on today.
I think that's it for now. Thank you.
Thank you.
All right, great. Thank you very much.
So presentation.
Incorporation of some revisions and rulings from May 9th. And then, because I'd signed up on a bunch of orders, but then whether those are incorporated into the parenting plan or kind of a separate order.
Right. So what we did is we made changes to the parenting plan. We're down to sort of 2 remaining issues. And so I'll address those. The first remaining issue is do you have the order in front of you?
Yes.
Okay, very good. So in looking at page 4, if you look about lines 23, 24, counsel's argument is that you awarded Mr. French every 3-day weekend in addition to the weekends that he's received. I don't believe that's Your Honor's intention. I believe your intention was sort of the standard language of if his regularly scheduled time falls on a 3-day weekend, then it would attach, which is the language that you see at page 4. So that's the first issue. And then the second issue is at page 7 is sort of the clarification that the cost of the flights will be apportioned per the child support order. But the question was the reimbursement. The court, when I looked at my notes and the clerk's minutes, the court said, yes, a timeline would be a good idea. And then I don't have anything after that, and neither does the clerk's minutes. My proposal was either 90 to 120 days. Ms. Bliss, I believe, is asking for 30 days. In this case, I'll remind the court that my client's portion of the flight costs could be somewhere between $1,200 to $2,000, and that's just assuming 2 trips in a month. Her income's $2,300. Ordering her to pay 95% of her income in a single month it's an impossibility. And so that's why, to me, 90 to 120 days allows her to ideally apportion that amount out over a couple months to be able to pay it back. It seems reasonable. So 30 days is just, I think we run into a contempt trap that we end up on a contempt where the defense is impossibility. So those are I believe, only 2 issues that remain for you to decide.
Thanks. Ms. Bliss?
Yes, Your Honor, and thank you, Ms. Baldwin, for recapping that for the court. Looking first to the 3-day weekend extended holiday. My recollection in reviewing your written ruling is Your Honor adopted my holiday schedule. Contained in my holiday schedule was that blurb that says extended weekends, days off from school, like in-service days, and all holidays that are otherwise listed, father shall have time. I believe that was the order of the court. That's simply what I'm asking for, is that be included. In review of Ms. Baldwin's language, it essentially suggests that if his time falls on a holiday or an in-service day or what have you, then his time shall be extended to Mondays. It doesn't give him that additional time, which I think was the intention of the court in ordering that in my holiday section. So I was asking for that standard blurb that was contained in my trial aid and contained in my proposed order for the time of trial that Your Honor essentially ordered. So that's that issue. The reimbursement issue. Yes, it is true. My client is asking for a 30-day reimbursement period. My notes are similar to Ms. Baldwin, as Your Honor ordered a timeline is appropriate, but then there was kind of trailing off at that point. And I don't think there was ever a definitive time frame. My concern is my client is bearing the brunt of these costs going for 3 months without any sort of reimbursement. It is a substantial hardship financially for him. I understand mom makes significantly less money. However, it was also discussed at trial that his child support be reduced and he would carry more of the brunt of the costs, and that wasn't ordered by the court, and it was refuted by Mrs. French. So we're at a point now where my client is exercising two visits per month, and is not going to be reimbursed for 3 months down the line. That's 6 visits in which he's bearing all of the costs and not getting reimbursed. So there are some substantial issues here. I am asking for 30 days. I would note that Your Honor kind of globally changed the timeline to 45 days for every other timeline throughout the order. So if we want to stick with consistency, I think 45 days would also be appropriate. But I do think that 120 days is just far too long.
Okay. All right. Thank you both. Go ahead.
So to address the flight costs, counsel is just simply incorrect. Right now, and until the child starts school and can fly unaccompanied, which is quite a while even after the child starts school, each party is paying for half of the costs. So Mr. doesn't bear the brunt. Both parties are equally sharing in the costs because Mr. buys the flight for his way out and to take the child back. And then my client books and pays the flights for her to travel and her to bring the child back. It's only when the child can fly unaccompanied, which I believe is like in the tween type ages, that Mr. then is booking all the flights. So right now, really, my client is the one that struggles both to pay for those flights. And again, especially with that lower income. So allowing that additional grace period is very reasonable. As far as the holiday schedule, if the court recall, the court fixed Miss Bliss's language that said that this doesn't begin until the child starts school. So the court already made substantial modifications. If you were to adopt her language as is, Mr. potentially would have 4 weekends or four visits in a month, which again creates these really wild impossibilities financially for frankly everyone. I think it's the court's intention to adopt sort of the standard language of when his trip falls on a regularly scheduled time period, that it encapsulates the sort of 3-day weekend. The language I've proposed does have like federal holidays, but also like school holidays and days where school's not in session. That's specifically in there in that language. So again, I believe that's the court's intention is the standard language, not to create a situation where he has, again, four weekends in a month.
Okay. And again, we're looking to the time when the child's is in kindergarten. That's what we're talking about at this point. Okay.
Yeah, correct.
All right. The unaccompanied minor costs and reimbursement, the time frame. Sorry for trailing off and not finishing that, and thanks for reminding me. I think 45 days is a reasonable time frame for reimbursement costs related to that. It's a little bit longer than the traditional billing cycle for a credit card. I think credit cards are 28, 25 days. It's a little bit longer than that, so that may cause some hardship. But extending much beyond that, I think creates even more hardship. So try to avoid that. So we'll set that at 45. Regarding the holiday schedule and the Mondays related to that holiday schedule, I recognize that the economics of these visits is problematic and really, in essence, in reality, precludes more frequent visits than what's basically laid out as far as the two per month. And so because there's kind of that financial reality, and also the fact that this is from my take on things, that the bond between mother and child and father and child is great. It's strong, it's beautiful, and it's to be nourished and continued. Long distance relationships are hard to nourish and foster. So my intent on that is for that additional time to be, if it can be had, then an additional weekend with a Monday could be included in that in the mix, and recognizing that has an asterisk next to it, that there's some financial realities that really put the damper on the potentiality of that happening with great frequency. So with that said, I'm not sure about that on page 4. I think when it says if Father's Weekend falls on a federal holiday or a school day is not had, then the child may be returned on Monday at 6:30 p.m. instead of Sunday at 6:30 p.m. Ms. Bliss, what's your proposal related to that particular paragraph?
I have no objection to the language in there. I think that that's necessary for in the events that we do have holidays on Monday. My suggestion was just adding a block into the holiday section that just said that standard, any holidays not listed, 3-day weekends, in-service days, what have you. So that it's clear that those are in addition to, because the language in section 8 is essentially if his time that he's already getting under that school schedule falls on this, then he'll have an extended time until Monday. I just think it's going to breed conflict if it's not very clear that it's additional time, not already scheduled time.
So, again, this becomes wildly problematic. So the child's not missing additional school. So then the language has to be Friday after school until Monday, and Friday without missing school till Monday at 6:30. So, I guess we can just alter the language to say if there's a Monday holiday or day school's not in session during the school calendar that falls on a Monday, then
Father could have a visit.
father can have a visit Friday to, Friday after school to Monday at 6:30.
Yeah. It's kind of what I was thinking, Ms. Bliss.
That's fine with me, Your Honor. I just wanted it very clear that obviously that's additional time, not his regular scheduled time.
As far as including that within this lovely document that's pristine, would interlineations be okay to do that today to save some money for your clients and then just take care of it that way?
That's my
That's fine
preference.
with me.
Okay, so I guess I could just simply add that, I don't know, there's room to write it in section 8. I can kind of draw an arrow down to the lower portion and say if there is a federal Monday holiday and or no school scheduled on a Monday, then the father can have a visit from Friday after school proceeding to that same Monday at 6:30, something along those lines.
That's fine.
Okay, all right, I'll do a circle and I'll include that in the proposed order and sign off on that.
I
Anything
think,
else?
no, I think once the court signed off on that, would you just confirm that all of the other orders have been entered?
Yeah,
Just want to confirm before we leave you, essentially.
right.
And Ms. Baldwin, that was the order you sent over late yesterday with all of the changes. Okay.
I just want to make sure that there isn't anything that remains.
On May 9th, I see a child support order was entered. Child support worksheets also. Decree of dissolution was entered and signed. Findings and conclusions were signed and entered that same day.
Okay.
So those have been entered and signed.
All right, very good then. Then this should be the last document.
Okay, great. So I'll include that on page 4, line 26 and a half.
Perfect.
Okay, great. Thanks, everybody. I appreciate your representing Ms. Willett. Mr. Roberts is on the line also representing Ms. Agovino. Ms. Corey is here as guardian ad litem, and I see that Ms. Willett is here and Ms. Looney is also here representing the state's interests. So we're on today. Let me get my notes for the mothers. Ms. Willett's motion to modify child support based on discovery that she's received, and so I've reviewed the pleadings. Any preliminary issues before we talk about that?
Nothing for me, Judge. Thank you.
Okay, great. Let's talk about that. So we'll hear from Ms. Bliss first.
Thank you, Your Honor. For the record, I do represent the respondent and moving party, namely Anastasia Ouellette. Before the court today is my client's motion to modify child support. As contained in my client's motion, when this matter initially began, we had very limited financial information from Mr. Agovino. At that time, he provided a statement essentially to the court saying that my projected salary is $8,000 per month. So the court took him at his word and imputed him at that, or calculated his income essentially at that $8,000 per month. Despite the fact that my client had provided to the court that he has always worked these types of jobs, always earned substantial commissions and bonuses and the like, the court just simply did not have that financial information at the time. Now, as we come before the court, we do have that information. I provided that to the court under seal, and I do believe that Mr. Agovino also filed some financial documents under seal. So I do think that the court is more prepared now than the first time we were before the court to address this issue. My client has provided to the court her analysis as to how she derived at her child support worksheets, looking at the first 1.5 months of the year. So through February 10 was the income information that we had at the time that this motion was filed. Mr. Agovino had already earned $26,993.79. This divided by that 1.5 month time frame is how we derived from the $17,995.86 that we have him included in the gross income of our child support worksheets. We're asking the court to use this income as his actual income, given the fact that it is substantiated by the pay stub provided by my client and by Mr. Agovino. It's clear that he's earning substantially more income than the $8,000 per month that the court previously found him to be making. And my client and the children have suffered accordingly. My client provides for the court that in January of this year, she was laid off from her job and had decided to go back to school in order to better herself, better her potential for a greater career. She provides for the court that as of right now, she's not receiving any financial aid. She is receiving some unemployment. So she's asking the court to find that she is to impute her income, as full-time minimum wage, given the fact that she's not currently earning any income. She understands and she provides for the court that in the fall, she intends on going to LCC, will be likely receiving financial aid at that time. So I'm imagining we're going to be back before the court at that point to readdress child support. But as of right now, my client, who takes care of the children 100% of the time, as your Honor is likely aware, Mr. Agovino is limited to professionally telephonic visits. So my client has these children in her care 100% of the time. She has extraordinary costs with raising 2 children in today's day and age, and the amount of child support that she's currently receiving from Mr. Agovino is simply insufficient. So we are asking the court to adopt our child support worksheets. This does require a transfer payment of $2,414.72. While I admit that is an astronomical number, we're also looking at astronomical finances and income from Mr. Agavino, earning nearly $30,000 after the first month and a half of the year. So there is sufficient evidence to support our request today. So we are asking the court to enter our child support worksheets as we've presented them. Secondarily, the last court reserved on the issue of the tax exemption, excuse me. Again, my client has these children in her care 100% of the time. Granted, Mr. Agavino is paying substantial child support, or will be if this order is entered. Notwithstanding him paying child support, it's simply insufficient to care for these children 100% of the time. So my client is asking, at least until he can potentially have in-person visitation, which at this point we don't know when that trajectory is going to be, but at least until that point, that she be permitted to claim both children for purposes of a tax exemption. So those are the requests that we have before the court today. Thank you.
Great. Thank you, Ms. Bliss. We'll have Mr. Robertson and Ms. Looney, please.
Good morning, Your Honor.
Good morning.
So my client has no issue with reevaluating child support. The question is what numbers we should use. Ms. Bliss and Ms. Ouellette took the first 6 weeks of 2021 as his income, when they had access to his full 2022 income. We've provided the broader context. As the court's aware, Mr. Agavino works on commission, and they included a massive pay period where it was a Christmas rush and a Christmas bonus. Her figures also, I don't know exactly how she reached the figures in her worksheet, but it suggests that she did not factor in California state taxes. Although Mr. Agavino lives in California, the income taxes in Mother's worksheet are lower than Mr. Agavino's worksheet, despite her gross figure being over $2,000 higher per month. The court has in the sealed financial source documents from both parties, my client's full 2022 information, his year-to-date income, and the first full 3 months of 2023, which we supplemented, showing that the Christmas bonus was truly a Christmas peak. His 2022 income was $161,000 for 10.2 months. He started February 23rd. This averages $15,819 per month. I admit a typo on page 1, line 2022 of my declaration. The equation in parentheses should have read 161 divided by 10.2 months, not 12 months, but the math was right. The typo was just a typo. His income for the first quarter of 2023, with the information that we provided through March, is an average of $15,600 and change. So showing that the numbers provided by Mother are simply inflated and cannot be accurately understood. He has provided to the court a year of income, and 6 weeks have been taken out of context. Therefore, his figures in the worksheet should be accepted. With respect to Mother's income, I'm truly confused about her position here. She self-reports unemployment income $890 a week. That's $3,857 a month. But she is imputing herself at $2,184, which is 57% of her actual income as of today. It is also 57% of the income of the child support worksheet last year. So based on our unemployment benefits, we attached an estimate from the Employment Security Department to try to figure out what's going on here. This estimates her income would have been approximately $7,700 per month in the 2 highest quarters of her base year to receive those 890 benefits. We know the unemployment benefits do not parallel actual income, so it only stands to reason her income prior to losing her job was well above that figure. Mr. Agavino's imputed her at $7,500 a month, $200 less than what the ESD data shows. Don't know what her actual income is or was, but we pieced together what we could based on the information provided, and logic and reason simply showed that her proposed worksheet is inconsistent with her own self-reported data, as well as the history of this case. Mother had an opportunity to reply to Mr. Agavino's declaration to clarify this, because I was obviously operating on limited information, and she failed to provide anything, which indicates that what was presented in our declaration was accurate or close to it. It appears she could re-enter the workforce at a considerable wage. I have no problem, neither does my client, with her going back to school, but she should not be able to inflate his income and significantly deflate her income, so he effectively subsidizes her education. With respect to the overall child support figure, there's the standard calculation plus the educational expenses that were in section 11B of the child support worksheet. Mr. Agavino does not believe she's incurred any expenses since the last child support worksheet, other than items that she specifically asked for reimbursement under section 22 of the child support order. He specifically reimbursed her for all of those expenses. There is currently $386 a month in that section 11B line, for which he is being asked in their worksheet to give her $337 a month for expenses that she has not provided. And despite calling it out in the response declaration, she provided no reply and no proof. Therefore, there's simply nothing in the record to justify these expenses. It should be removed. And if there are any educational expenses that fall under the provisions of Section 22, they should be determined on a case-by-case basis.
Thank you, Mr. Roberts. Ms.
And if
Lewin?
I could have, I'm sorry, if I could have just 1 minute, I apologize. I was looking back at my notes and looking at you.
No, I jumped in too soon. Sorry.
No, it's fine. I stalled. So at this point, the 337 appears to be a windfall given the information that we have. Also, with the high conflict between the parties, my client requests that any Section 22 expense is sent, the invoice sent directly from the service provider. He pays the service provider. These parties have a troubling history, and he doesn't want to be writing checks to her. He's happy to write checks to the school if the invoice is legitimate. With respect to the tax issue, my client's not claimed the children since 2018. That's obviously in the past, but even according to mother's own statement, she's not going to have almost barely any income for 2023, yet she's asking for her to claim the children, which I don't even know if that's going to grant her $1, but it's going to certainly deprive my client from significant funds when she's asking to pay him her to pay him over $2,000 a month. There's no basis for that, and it's consistent with her inflating his income, deflating hers, and it appears retaliatory, and there's no basis for it. Regardless of contact with the children, if my client's going to pay $25,000 a year in child support, he should be able to claim the children, especially when mother's not even working because she's going to school. So in conclusion, we're asking the court to adopt my client's figures for his income in his worksheet, which is based on his 2022 average as well as his full 2023 average through March. Also use the mother's income in my client's declaration. At the very least, mother's income should be imputed at $3,857, which is her actual income per her self-report. Education expenses in 11B of the child support of worksheet be removed. Everything under Section 22 of the child support order made directly to the service provider, not to mother, and he would request that he can claim the children for 2023 and odd years thereafter, so long as he is current in support by January 31st of the filing year.
Okay, thank you. Ms. Looney.
Thank you, Your Honor. I apologize. I did not get any numbers to anyone in writing. I was out most of last week and did not see Mr. Agavino's new income information until Friday. That being said, the state's interest is just as to medical in this case, but I do have some slightly different calculations than either of counsel has presented today, just based on standard practice that we would do here with the state. We did take Mr. Agavino's 2022 income that was presented in his declaration of the 161,363. Our standard practice would be to just round that to a 10 months rather than a 10.2. So that gave us a gross income for him of $16,136. We also used the employment security data that we filed at Ms. Bliss's request in January of this year to get an estimated income for Ms. Ouellette for those first 3 quarters of 2022 of $54,890. If you divide that by those 9 months, that would give her an estimated gross income of $6,099 per month based on that historical data. We're not asking the court to use those numbers. We just want to present them for consideration. We don't have any interest in what that full transport payment would be or what other credits or deductions the court would order based on other information. And we just wanted to present that to the court today.
Thank you, Ms. Looney. I'll give time to Ms. Bliss and also Mr. Roberts if you have any additional comments based on Ms. Looney's and also Mr. Roberts' comments.
Thank you, Your Honor. And just briefly, as it relates to my client not filing a reply declaration, I will take the heat on that one. That was an issue with my office, not with regard to my client not being prepared to respond to this. Instead of asking for a continuance today, we were prepared to move forward. If Your Honor does want her position on some of the issues raised, I'd be more than happy to file a declaration. Right after this hearing, however, I was in lieu of judicial economy, I was prepared to just move forward today without a written response from my client. Nevertheless, the income information that we had at the time that the motion was filed was through 1.5 months of Mr. Agavino's 2023 income. That is the income we've used. So to claim that my client is inflating his income is inaccurate. It's based on his pay stub that he has provided. So we are asking the court to find that his income is $17,995 gross. I would also note too, looking at his 2022 W-2, he only claimed $9,000 $2,000 in income taxes for the year, which I believe my child court worksheets had him at $2,321 per month. So obviously taxes are a huge issue. He is not paying consistent taxes, whether that's owed at the end of the year or not. He's not paying them consistently throughout the year. So that does need to be considered by this court. He has a significant gross income. He's not paying accordingly, and that needs to be taken into consideration. Looking to the tax exemption, again, my client has 100% physical custody of these children right now. 2,000, 2,500, what have you, is simply not enough to cover the expenses that it costs to raise two children in today's economy when there is no other support from the other parent. My client is asking for the tax exemption until Mr. Agovino can exercise in-person visitation and bear the brunt of those visits as well, the costs that are associated. And I think that that's appropriate. If the court is inclined to award him a tax exemption, I would ask that the parties split each child every year so that they both have the benefit of claiming a child for purposes of tax exemptions. But I do believe that our initial request of mother claiming both children until Mr. Agovino begins in-person visitation is appropriate, is warranted. So that is our request before the court today. With regard to the $386, I believe it is in section 11 of the child support worksheets. I believe that was inadvertently left in from the temporary orders. I would note that they are in the temporary worksheets that the court had entered previously. I would just say that I would agree with Mr. Roberts that shouldn't be included, given the fact that 22B has those uninsured education expenses. So I would not be opposed to removing that. I do just think that those were left in inadvertently from the previous orders. So our requests before the court today are reasonable, are substantiated by the evidence provided, and are appropriate in this matter.
Thanks, Mr. Roberts.
So, Your Honor, with respect to the month and a half in 2023, I understand that's all Ms. Bliss had as of the time of filing for 2023, but she had the 2022 data. She filed it under seal, and that was provided by me to her. So it's just not accurate that they only had those pay stubs to go off of. With respect to the deductions in the income tax, this was explicitly addressed in our declaration. And we attached 2 exhibits 1 and 2 to help the court understand this argument potentially from Ms. Bliss. My client was starting a new job. For the first time, he had unemployment for a while. He got deductions that were under the average, knowing he was going to pay, had a tax burden at the end of the year. Exhibit 1 is a statement from his accountant saying this is his estimated tax burden for tax year 2022. We haven't filed yet because they were behind, but the exhibit's there. It's from his accountant. And exhibit 2 is calculation I pulled from Smart Asset, which is a reliable tax calculator that gives rough estimates of what people owe when they live in certain zip codes. And that's what I pulled everything from. So the numbers that are in his worksheet are both consistent with the Smart Asset calculation, as well as the information from his accountant. He's not hiding funds and then where he's going to be audited by the IRS and have to pay $200,000 in a few years. He's going to be paying it soon, which is why he has an accountant, which is why the accountant wrote the letter and why we've provided it to this court. I think those are the only issues. The state's numbers for mother of 6,100 make a lot more sense given my argument of thinking it was about 7,500. I think the court's heard my argument. I'm not going to belabor the point, but I think the way the state has figured mother's income out makes a lot more sense than 1/3 of that as her income. And with respect to the tax issue, I mean, I understand mom is providing all the care, but she's getting, even under our worksheet, she's getting considerable money. And if my client's paying money, he should be getting some benefit. Splitting the children 1 per year, I don't think there's a significant issue for my client, whether it's both children or 1. I think this year, it probably makes sense that my client gets both because she's not going to be making any money. So when she starts making money, she can do that, but I'm going to leave the point and let the court make a decision accordingly.
Thanks everybody for your input. I appreciate that. So, so it looks like, Mr. Agovino's, we have a much more clear picture of what his monthly income and yearly income has been. He started his job back in February. And with auto sales, I think, for most auto sales persons, they can do fairly well, and there's some degree of consistency, but certainly there are ups and downs, and there's good months, there's bad months, there's reasons why people buy cars, there's a lot of macroeconomic stuff pressing down on things. So granted, the early months of this year have been pretty good for Mr. Agovino. If you look at the longer term picture, it provides a little more context. It's not necessarily inaccurate, but it provides, I think, a more fair picture. So his gross, I'm going to set his gross at $16,000 per month with a net of $11,000 per month. I think that's a fair figure. Fair figures based on kind of the fluctuating nature and taking into account bonuses and the like of car sales. So with regard to the mother's income, it looks like she was working at another job that paid well. That job was no longer. She's receiving unemployment benefits of just under $4,000. So there's some historical information that's been provided by Ms. Looney and also Mr. Roberts. So I'm going to impute her income at $4,200 per month. With regard to the tax exemption, I think both parties should share the tax exemption. So in odd years, the father can claim the older child, and in even years, the mother can claim the youngest child. So that's kind of just the division. They'll each claim one. Sorry, that was confusing. That didn't come out. Let me try again. So they can each claim one child per year. So no odds and evens. The mother will claim the youngest child, and the father will claim the oldest child. Then with regard to the educational expense, the 11B in the worksheets, the concessions well received. So we'll remove the 386 and just leave that as written in the section 22, which is the proportional share of the educational expense. So the parents feel that's a priority, and so that's great that they're doing that with their children.
With respect to section 20, I'm sorry, Your Honor, did you finish? Yeah. I'm sorry.
No,
I want to request that section 22, that the box moves from to the person that pays the expense to the service provider. It's a high conflict case, and my client would really prefer to pay the school and any service provider directly.
Any concerns with that, Ms. Bliss?
Your Honor, I think that this is more of a registry issue. I know historically they have instructed, at least the state, when you can correct me if I'm wrong, they've always instructed us to put reimbursement to the person who pays the expense, so that when mother essentially sends the receipts to the registry, they can collect the funds. So if you say the other party will pay the provider, then mother can't necessarily utilize the registry's benefit of that. But again, I don't know if that's necessarily still the case. I know historically that was always it. So I guess I would defer to Ms. Looney on that one.
Ms. Looney?
Ms. Bliss' recitation is correct, Your Honor. DCS will not be able to assist in collection of the funds if it was paid to the service provider, because they aren't allowed to represent the service provider, only the individual. So it would need to be paid to the person who owes the expense.
So I think everybody makes good points here. I can understand Mr. Agavino's viewpoint of wanting to pay it directly to the provider so that they know that they're getting the money and that obligation is satisfied. And I get where Ms. Willett is coming from also, that having the benefit of the registry to assist in collection is beneficial. So I like them both. I want to keep them both. So I don't know if there's some language to be added in section 22 that, although it says make payments to the person who pays the expense, maybe some asterisk that says that it's paid into the registry for the benefit of the person who pays the expense. I'm just not sure how to represent that.
And Your Honor, if I may, I don't think I think it becomes an issue when it's not paid directly to the provider. So if he is to make the payments directly to the provider, then mother won't need the use of the registry for reimbursement, because she's not paying 100% of the cost and requesting reimbursement. So I don't think there's any issue with including language that says, invoices for expenses shall be provided to father. And I think that that's frankly something that probably can be worked out with the school. They could probably send him invoices directly, or I can arrange for my client to do that. But I want to keep the language that allows my client to utilize the registry in the event that he doesn't pay, and she's bearing 100% of those costs, if that makes sense.
Does Mr. Roberts?
I would defer to Ms. Looney. I was unaware of that wrinkle. Otherwise, I would have caveated my argument. So I apologize for that. I would defer to Ms. Looney. The court knows my position, but I'm not. If she wants to use the registry, she gets to use the registry, I suppose. If Ms. Looney can inform the court of what she thinks can work, and then you can make a decision, I have nothing else to add.
All right, Ms. Looney, we look forward to your wisdom.
Well, it's not really changing much, Your Honor. It would just need to be paid to the person who pays the expense. The Division of Child Support is not able to collect if that box is checked for the payments to go directly to the service provider. But as Ms. Bliss stated, they can work that out so that invoices could go directly to Mr. Agavino. It just becomes an issue if the payments are not made. That gives her recourse to be able to get assistance from DCS to collect the payment that she would not have if it was paid to the service provider only. And we can't have both boxes checked on the form.
Can I ask a question? Is it possible to have the payment made to the person who makes the expense, but have it paid directly to DCS on her behalf, or would it have to go directly to her? And if there's an issue, then DCS gets involved?
That I'm not sure if it can go directly to DCS for uninsured medical. I'd have to look into that. But as Ms. Bliss said, it could go directly to the service provider, and there shouldn't be an issue so long as everything's paid. This provision just allows for DCS to help with collection if payments are not made.
Okay, thank you.
And it's my recollection, just based on practice, is typically if there are outstanding expenses, clients send the invoice or the receipt or whatever to DCS, and then that's typically when they begin collecting. So I guess in essence, Mr. Roberts, if my client were to submit the invoice of the paid expense in full to DCS, then they would contact him and have him pay his proportionate share. So it technically would be going to the registry and then to my client. So I don't think that I think your concern is cross payments between my client and yours and the conflict. So I think that that's navigated through the registry. So that shouldn't be an issue. at least.
That
hopefully.
sounds good enough for me for now. And then if we run into an issue, we'll have to learn more later, but that's fine, I think.
Okay. Good. That was an enlightening discussion. I appreciate everybody's input on that. That was very helpful. All right. So with the court having provided that input and decisions, we have some proposed orders that probably need to be adjusted, but I think I can at least sign off on. Well,
Temporary family law order.
yeah, the
Maybe.
temporary family law order, it says that the court signed the temporary child support order and worksheet filed separately, which isn't exactly true because I haven't signed them. So maybe we
We
should
could just
hold off
resubmit.
on, yeah, resubmit.
Yeah.
Um,
And I imagine Mr. Roberts and I can probably reach an agreement on this, but if we want to just have a back date of that June 6th, I think was your next date on docket.
right. Yeah, if the parties, yeah, we'll set for June 6th at 9 a.m. If that works for everybody, we'll set that as just a backstop. And if it doesn't work, if the parties can't come to an agreement, then we'll be here on the 6th. Otherwise, we can receive the documents ex parte and sign off on them.
Okay. And Judge, just one point of clarification, you indicated mother's income would be at $4,200 per month. Was that gross or net?
Net.
Okay.
Net imputed. Yeah, thank
Okay. I will make those changes and circulate those and hopefully get some signatures.
I think we'll be good. I appreciate everyone's help. I think we're clear now and we can get this to you very soon, Your Honor.
Okay, great. Thanks, everybody. I appreciate it very much. So that'll conclude the Agavino will that matter for today. And I believe that concludes the matters that were on this morning's family law docket. So appreciate everybody for staying for the long haul.